So this week an appeal was filed in the Supreme Court that is inviting the court to overrule the Obergefell decision, the 2015 decision that held that there's a constitutional right for same-sex couples to marry. This isn't a huge surprise. You know, in Dobbs, the case that overruled Roe versus Wade a few years ago, the court basically invited people like Kim Davis, who filed this most recent appeal, to challenge Obergefell. And Justice Thomas said it out loud, come on, we're ready, let's take on Obergefell. So you may remember Kim Davis is the public actor, the official in Kentucky, who normally issues marriage license, but after Obergefell, she said, well, because of my religious beliefs, I refuse to marry same-sex couples, and as a result, I won't issue any marriage licenses. And she was sued, and the courts ordered her to issue marriage licenses in conformance with Obergefell to both same-sex and different-sex couples. She actually went to jail for 6 days over this, and this is something highlighted in the appeal that was just filed in the Supreme Court. Oh my God, Kim Davis is the only person who's ever had to go to jail, serve jail time for her religious beliefs around same-sex marriage. Well, she was jailed because she was in contempt of court. She refused to follow the court's orders. There was an appeal that she could have followed that would have been the regular way of dealing with this, but instead she dug in and refused to follow the injunction. So, in fact, she was jailed for not following a proper court order. She wasn't jailed because of her religious beliefs. But this new appeal that was filed this week by Davis does several things that are worthy of note. And there's been some publicity in the media about the case, but I want to get a little bit deeper than what a lot of the stories have said. There are two major things that I think are really important here. The first, of course, is her request that the court revisit Obergefell. And what she's arguing in her brief is that Obergefell was wrongly decided from the beginning, and erroneously and egregiously so, which is what the court held in Dobbs. So they're basically borrowing all of the same language from the Dobbs decision and saying this applies in a similar way with respect to Obergefell, because that case, Obergefell, rested on a right to substantive due process, as did the abortion right in Dobbs. And for those jurists and advocates who are very deeply textualist, the word substantive due process don't appear in the Constitution, must be made up. And then whatever the right is that is secured under substantive due process, whether it's abortion or gay rights, there is no history or tradition, they argue, of protecting abortion rights or same-sex marriage. But in the case of Obergefell, actually, this is something that the court visited in Obergefell and talked about also in the earlier gay rights cases. That despite the fact that there isn't a history and tradition of respecting gay rights, that doesn't answer the question. So, in fact, overruling Obergefell will have a broader jurisprudential impact, meaning that the court will have to make a bolder ruling to overrule Obergefell than Dobbs. Because Obergefell actually took up this history and tradition question and rejected it, which was not true about Roe. If you look at the Bowers versus Hardwick decision from 1986, which dealt with gay rights and said there's no history and tradition of respecting same-sex sex as a constitutional right. Lawrence versus Texas, that overruled Bowers, actually took on this history and tradition argument and rejected it. So if this is the basis on which they want the court to visit or revisit Obergefell, they're going to have to look at Lawrence as well, and that's very troubling. The other part of Davis's appeal to the Supreme Court that ought to get attention but actually hasn't been mentioned in the media is the degree to which she is wanting it both ways. And by both ways, I mean she moved to have the case dismissed under 11th Amendment sovereign immunity grounds and won that argument. And that means that she was able to prevail in an argument that when she is acting as a public official as the state, So she's not just acting as an individual, but is acting as the state. And when you issue marriage licenses, it is actually the state of Kentucky that is marrying you, not Kim Davis, right? When you act as the state, you are immune from monetary, that is, financial damages when you violate the law. The case just has to be dismissed outright. And she won on that. She then goes on to say that when I was also sued in my personal capacity, not just my official capacity, acting as the state, but my personal capacity. And in that sense, money damages were awarded to the plaintiffs against her. She says, well, I'm entitled to use the First Amendment's religious liberty protections as an absolute defense in the case against the personal claims against me or against me as an individual. But she, on the one hand, has said she was acting as the state and officially, and then is asserting privately a First Amendment defense, but she can't have it both ways. And the reason she can't have it both ways is that the state of Kentucky doesn't have First Amendment rights. Individual citizens do. And so either she was acting as a private party or as the state when she denied these marriage licenses, and the courts already ruled on her request that she was acting as the state, and in that sense has likely waived the ability to raise religious liberty defenses saying, well, I did so because of my faith. But the state can't have a faith, only individuals can. Now, this is actually a question about which there's not that much law, and so the Supreme Court could actually make new law granting a whole new way of thinking about the First Amendment as it relates to state actors that would really expand First Amendment rights while at the same time deeply contracting the rights of gay people. So we'll see what happens in this case, but these are the things to look for.